Welcome back to the deep dive. Today, we are wading into some incredibly murky and, frankly, tragic legal waters.
It's a heavy one for sure.
We're looking at a situation that happens all too often, a house party, way too much alcohol, and a medical emergency, but we're looking at it through a very specific legal lens.
Right.
The tension between the rule that says you generally don't have to rescue someone and, well, the liability that crashes down on you if you decide to help, but you mess it up.
It is a heavy topic, but legally, it's one of the most important distinctions in tort law. It's really the difference between being a bystander and being a participant in a tragedy.
The case we're unpacking is Wakulich v. Mraz. It's a gut-wrenching scenario involving a 16-year-old girl, a quart of high-proof alcohol, and a complete failure to call 911.
Mm-hmm.
But the core problem we're solving isn't just about underage drinking, it's this. Can a social host be held liable for the death of a guest? Not because they served the booze, but because of how they handled the guest passing out.
Precisely. And to get to the answer, we have to follow a very specific analytical path. First, we're going to look at the baseline no-duty rule for social hosts, essentially why you generally aren't your brother's keeper at a party.
Okay.
Second, we'll dissect the voluntary undertaking exception, which, is often called the Good Samaritan doctrine. And finally, we'll apply those rules directly to the Wakulich case to see exactly when doing nothing transforms into a legal breach of duty.
The mission here is to figure out where that line is drawn. So let's start broad. Let's open the doctrinal inquiry. Under the common law generally, does a social host owe a duty to supervise an intoxicated guest or seek medical attention for them? If I throw a party and you drink too much, is it my legal job to watch you?
The short answer is no.
Yes, no.
The general rule is that absent a special relationship, like, a parent-child or carrier-passenger, a social host, has no duty to supervise an intoxicated guest or come to the aid or assistance of a person who voluntarily chose to drink.
That seems harsh. Are there cases that back that up?
There are. We look to cases that establish the baseline that social hosts are generally insulated from liability regarding the provision of alcohol. The courts have just been very, very hesitant to mandate that a host must monitor the consumption levels or the physical condition of every person who walks through their door.
So the law puts the consequences on the drinker.
For the most part, yes. If you choose to drink, the law generally puts the consequences of that choice on you.
Okay, so that's the shield, the no-duty rule. But here's the counter concept, and this is where it gets really interesting. If the host decides to help anyway, if they see someone in trouble and decide to step in, does that change the legal landscape?
It changes everything. This brings us to the exception rule, the voluntary undertaking doctrine.
Okay.
The rule is, and this is key, one who voluntarily undertakes to render services to another is liable for bodily harm caused by his failure to perform such services with due care or with such competence and skill as he possesses.
So once you start, you're on the hook.
You are. And to trigger this, you need three elements. First, a voluntary undertaking of services to another. You have to actually step up.
You have to do something.
Second, a failure to perform those services with due care. You have to be negligent in how you help. And third, bodily harm must be proximately caused by that failure.
It's the classic don't make it worse principle.
Exactly. If you're going to rescue, you have to rescue reasonably.
All right, let's see how this plays out in the real world. Let's analyze Wakulich v. Mraz. First, what are the legally dispositive facts? What actually happened that night?
It's a harrowing set of facts. Elizabeth Wakulich, just 16 years old, was at the Mraz family home. Two brothers, Michael, who was 21, and Brian, who was 18, were there. And they offered Elizabeth money to drink an entire quart of Goldschlager, a high-proof cinnamon schnapps, without losing consciousness or vomiting.
A quart. That is a lethal amount of alcohol for anyone, let alone a 16-year-old.
It is. She drank it, and inevitably she lost consciousness. This is where the facts become critical for our legal analysis. The brothers moved her to the family room downstairs. They saw her vomiting profusely and making gurgling sounds.
That sounds like a medical emergency.
It was. But here's the care they provided. They changed her vomit-saturated blouse, and they placed a pillow under her head to prevent aspiration.
So, trying to keep her from choking on her own vomit.
Right. But the negligence comes in what they didn't do. They did not call 911. In fact, the complaint alleged they actively prevented other people at the house from calling 911 or seeking emergency help.
And the outcome.
The next morning, the father, Dennis Mraz, ordered her removed from the house. The brothers took her to a friend's house, and she was later pronounced dead.
Just tragic. Okay, let's look at the law. What was the core legal issue here?
The issue is whether the plaintiff Elizabeth's estate pled sufficient facts to establish a cause of action based on the defendant's failure to exercise due care after voluntarily undertaking to care for the unconscious decedent.
So basically, did their actions create a duty where there wasn't one before?
Exactly.
And what rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
Of course. The court applied the voluntary undertaking doctrine. The rule has 3 distinct elements. First, voluntary assumption. The defendant must affirmatively undertake steps to care for the plaintiff.
Okay.
Second, breach of due care. The defendant must fail to exercise reasonable care in performing that undertaking.
Got it.
And third, proximate cause. The harm must result from this negligent performance.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, voluntary assumption of duty?
So the sub-issue here was pretty simple. Did the Mraz brothers' actions actually constitute an undertaking of care?
Right. Did they do enough to trigger the rule?
Yes. The defendants argued that their acts didn't indicate assuming responsibility. They were just, doing bare minimum things. The court disagreed entirely.
And what did it point to?
It looked at the specific acts. Carrying her downstairs, placing her on a couch, checking on her, changing her vomit-saturated shirt, and specifically placing that pillow to prevent aspiration.
The pillow seems really important.
It is. The court even compared this to another case where a club member merely checked on a pledge and heard gurgling. That was enough. The court found that the Mraz brothers' actions more clearly demonstrated an undertaking than even that case.
So the conclusion for element 1 was what?
Met. They voluntarily assumed a duty. End of story for that element.
Understood. They took charge. Now, what about the second element, breach of due care?
Okay, so the sub-issue here is, once they started caring for her, did they act reasonably?
Which seems like an obvious no, but how did the court analyze it?
Well, the rule requires the undertaking to be performed with due care, and the application of facts here is just. It's devastating for the defendants. The complaint alleged they saw her vomiting and making gurgling sounds.
Clear signs of distress.
Exactly. These are clear signs of respiratory distress. Yet, they failed to seek medical attention. But crucially, and this is a major, major factor, they prevented others from calling 911. A reasonable person seeing a teenager gurgling and unconscious calls for help.
And they certainly don't stop someone else from calling.
Right. So, the conclusion for element 2, met. A jury could easily find that preventing medical intervention while the victim is in that state is a negligent discharge of duty.
And after analyzing all the elements, what was the court's final conclusion?
The holding was a reversal of the trial court's dismissal. The key logic is this. The defendant's status as social hosts does not insulate them from liability for failing to exercise due care in a voluntary undertaking.
So that shield we talked about, it shattered.
It shattered. By taking charge of her care, they stripped away the no-duty protection. They were required to care for her reasonably, and the court found they failed to do so.
It's a powerful ruling because it pierces that whole shield of, it was just a party. Okay. To really solidify this, let's test the boundaries. I want to throw some hypotheticals at you. Let's call this first one the cold-hearted host. Suppose the brothers simply watched her pass out. They stepped over her body, went to bed, and did absolutely nothing. No pillow, no moving her to the couch, no changing her shirt. She dies on the floor. Liability.
This is the hard part of the law, and the analysis suggests likely no liability under the strict social host rule.
Even though that feels completely wrong.
It feels morally wrong, absolutely. But remember, the duty comes from the undertaking. Without those affirmative acts of care, the pillow, the shirt change, moving her, the voluntary undertaking duty never attaches. It is a harsh result, but legally, if you do nothing, you generally cannot be sued for negligence in this context.
That is chilling. It almost incentivizes total apathy. Okay, let's try another one. The interfering Samaritan. Suppose they didn't touch her. No pillow, no shirt change. But they stood in the doorway and physically blocked a friend from calling 911. Don't call the cops. We don't want trouble. But they don't do anything else.
This isolates the interference aspect, which is interesting. So they didn't undertake care in the sense of nursing her, but preventing aid is a distinct form of misfeasance.
So is that enough?
It might be, but in Wakulich, the court really emphasized the combination. The court found the facts gross, specifically because they simulated care, they put the pillow under her head, acting like they were handling it, while blocking real help.
Right, because by putting the pillow there, they're signaling to everyone else, we got this.
Exactly. And reliance is a huge part of why this doctrine exists.
Mhm.
If you look like you are helping, other people stop trying to help. And if your help is incompetent, you've left the victim worse off than if you had done nothing at all.
So for the listener who wants to keep this straight, maybe they're a law student or maybe they just want to understand their liability, how do we synthesize this? Can you give us a diagnostic checklist?
Absolutely. Think of this as your exam framework or your liability checklist. Step 1. Identify the relationship. Is it a social host-guest scenario?
Yeah.
If yes, start with the presumption of no duty to supervise or rescue. That is your baseline.
Always start there.
Always. Step 2, check for affirmative acts. This is the trigger. Did the defendant do something? Look for moving the victim, providing comfort items like pillows, cleaning them up, or checking on them periodically. If you see these facts, that no duty shield is cracking.
Okay, and if it cracks?
Step 3, analyze the quality of performance. If step 2 is a K, yes, a duty has attached. Now ask, did they act as a reasonable person would? Red flags to look for are 1, preventing others from helping.
That's a huge one.
Huge. And 2, recognizing severe symptoms like gurgling or aspiration and failing to call professionals.
Can't fight.
Step 4 is the conclusion. If the performance was unreasonable, liability attaches. And remember, the liability attaches not for the alcohol, but for the botched rescue.
It's a very clear if sobering framework. As we wrap up, there's a distinct irony here, isn't there?
There is. The defendants in this case might have been safe from civil liability had they done absolutely nothing.
It's unbelievable.
Had they been truly indifferent to Elizabeth's suffering, the law might have protected them. But because they tried to manage the situation, likely to avoid getting in trouble, and because they did so incompetently and secretively, they created their own liability.
The law punishes the incompetent rescuer more severely than the indifferent bystander.
That is the bottom line. If you are going to get involved, you have to get involved competently. You cannot half-measure a rescue when a life is on the line.
And that leaves us with a provocative thought for you to chew on. We want to believe the law encourages us to be good Samaritans. But does a rule like this actually do the opposite? Does it encourage people to walk away from friends in distress just to avoid the risk of doing it wrong?
Something to think about.
Think about that the next time you see someone who needs a hand. Thanks for listening to The Deep Dive.
Stay safe out there.